First on CNN, the Justice Department targeting another Trump adversary. Multiple sources telling CNN that DOJ has launched a criminal investigation into E. Jean Carroll, the woman who had accused Trump of sexually assaulting her in a New York department store in the mid-1990s. In 2023, a jury found Trump liable for sexual abuse and defamation of Carroll and awarded her $5 million. The following year, a different jury ordered Trump to pay Carroll more than $83 million in a second case. We're told that the new probe is focused on whether the former magazine columnist committed perjury during one of her depositions involving the first case when she testified that her lawsuits were not funded by outside sources. Her lawyers later revealed a couple weeks before the trial that billionaire Reid Hoffman, a nonprofit associated with him, had paid some of Carroll's legal fees and expenses. We should note that Carroll is still fighting multiple legal battles with the president. He has appealed the $5 million sexual abuse judgment to the Supreme Court and has pledged to do the same with the $83 million defamation case. So far, the Supreme Court has passed on this. We're joined now by James Sample. He is a professor of law at Hofstra University. James, it's important to note that this issue of her deposition and the outside payment of legal fees and expenses was dealt with in the trial. Does DOJ have a case here? Explain what was done in that 2023 trial and whether or not that affects this investigation here.
Brianna, you are absolutely right that is a critical clarification, and it does make a huge difference. Judge Lewis Kaplan of the Southern District of New York presided over both of the underlying trials. And after E. Jean Carroll's lawyers disclosed to Alina Habba, who at that time was representing the president in her personal capacity and in his personal capacity, they then disclosed the information to the trial court as well. And Judge Lewis Kaplan actually gave the Trump team the opportunity to engage in a supplemental deposition focused on this narrow question. He then reviewed that deposition, reviewed other testimony, determined that E. Jean Carroll had been credible and that she didn't come anywhere near the standard of perjury. And again, it's worth reiterating, she and her team disclosed to Trump's team the discrepancy in her initial testimony. So after that disclosure, Judge Lewis Kaplan allowed this examination to go on. He tested it, he examined it, and he resolved the matter in favor of E. Jean Carroll, finding that she was entirely credible. Why that's important? Two reasons. One, it means this matter has already been litigated and has already been litigated by the very same trial judge who heard the underlying cases themselves. That's critical. In the law, we would call that matter res judicata. The thing has already been adjudicated. The other factor is that this case is being brought by the Department of Justice in a case that is absolutely, entirely, and 100% about Donald Trump in his personal capacity. So as Adam Smith made this point last night with Anderson Cooper, the president is, in this case, even more so than in some of the other retribution cases, using the Department of Justice not just for retribution against his enemies, but for retribution against his perceived enemies in a matter that was entirely based on his private citizen conduct.
James, let me ask you, because this deposition in question here occurred in New York. That's not where this investigation is taking place. Is that unusual? What questions does that raise?
It is unusual. We don't know exactly the reasons why, and so some of this is a bit speculative, but it is a bit of a tell. The deposition took place in New York. The underlying cases took place in New York. LinkedIn and the nonprofit that is associated with this funding question is based in Chicago. So there is a venue hook that is at least plausible, but this certainly begs the question, why wouldn't you bring this in New York? Possibly, and this is a matter of speculation, possibly because you needed to look for a friendly forum and a friendly U.S. attorney who would be willing to try and investigate this kind of a claim.
So this verdict has been appealed multiple times. It has survived. We should be very clear about that. Is it possible that the investigation is the point here? How onerous is an investigation even without an indictment?
I think that that is absolutely correct. I think that the investigation is the point. This is not a winnable case for the Department of Justice. Even if there were merits to the claim, and it's already been determined that there are not merits to the claim, that's actually been determined. It is an extremely high bar to establish perjury. You require a knowing falsehood, that the individual testified knowing it was false and that they intended it to be false. That's a high bar in a normal perjury prosecution. Here, you'd be talking about a perjury prosecution that's already been adjudicated. The point of this is to exact the harassment, to exact the time, the inconvenience, and the annoyance, frankly, of knowing that you are the subject of investigation being spearheaded, presumably, by the President of the United States.
James Sample, appreciate you joining us. Thank you so much.